Hi, everybody. It's Thursday. It's June 11th, 2015, and it's time for my private audio call. Tonight, our special guest speaker is Merrill Frantz and his lovely wife. I don't know your wife's name.
Diana.
And Diana is on the chat, so you guys be nice. Don't beat up on her now. And Merrill's going to talk.
I'm trying to restrain myself.
I'm sorry, what?
I said I'm trying to restrain myself.
Okay.
You said don't beat up on her. I said I'm trying to restrain myself.
Okay. Anyway, Merrill, why don't you tell us a little bit about yourself? You're going to be sharing with us your knowledge of the common law, right?
Well, yeah, so to a point, yeah. There's not really a lot to tell. I've been studying here for 30 years or so. And, I've been involved in various situations, altercations with the law and the civil authority and going to jail for this and that and the other. But I'm not a ne'er-do-well. I have a business here in Washington that's been successful, which I'm retired from. But, I understand, I understood from an early point that something was the matter with the system. Something wasn't working the way it should, We weren't experiencing the freedoms that we were supposed to have. And there were just too many things that were happening that were kind of oppressive, and so it was a great wonder to me that though our country is the greatest country on earth, founded on the English common law, and we're supposed to be law abiding and all that, and I thought the civil authority is supposed to be that way too, but it didn't seem that way, and so I started studying. And so I guess there's a couple things that must first be understood before you understand anything else that's going on out there. There's only two ways under our system of laws, the Fourth and Fifth Amendment, whereby a criminal charge can be levied against you. I don't know if anybody knew or understood that. Does anybody out there understand the subject of subject matter and how is it established?
I believe so, but
okay, then you know that the only way that subject matter in a criminal prosecution that can come forth is under the Fourth and Fifth Amendment. Does anybody believe it's any other way?
Well, it's not like I have everybody else muted out to avoid making a lot of noise. So,
well, most assuredly, how many people out there, raise your hands if you want to, have really have been arrested under a Fourth Amendment warrant or a Fifth Amendment warrant?
Anybody?
Virtually nobody, right? Nobody
right,
does.
Right.
Why? How is that? What process? And everybody claims, oh, geez, they're shooting down the Constitution. They're not following it. They're following the Constitution to the letter.
All right, we're back. Okay, sorry about that. Skype is giving me fits. It does this to me every time I have a talk show call now, it seems like. I don't know if it's a government thing, the NSA doesn't like what we're saying, or if it's just, I talk on Skype all week long to people, and it doesn't do this. And then when I get on talk show, it does this. So I don't know what's going on. I'm sorry about that. We just lost about, 15 minutes? Jeez.
How long is the program?
Oh, we can go for as long as you like. Normally it's 2 hours.
2 hours? Well,
yeah.
I don't know if I can hang there that long, but I will say this before we commence this time. I've written a book.
Oh, okay.
Anybody interested in, goodness gracious, just get a hold of you and we'll make contact, okay?
Yeah, absolutely. Do you have a website or anything you want to give out, or?
Well, not at the moment. We don't have it on the website, so, those plans in the future.
Okay. Well, we'll get all your contact information, and we'll put it on my website, myprivateaudio.com, so anybody that wants it can just, get it from you directly.
What I have to understand here, Angela, is how does this thing work? Is someone going to talk to me, or do I have to watch on the screen for someone asking a question or whatever?
Oh, no, you don't have to watch the screen. I'm going to talk to you, and after you're done telling us, or sharing with us some of your insight and experiences, Then we'll have Q&A, and what happens is all the people that are on the call that have a question for you, they can put up their hand and ask a question by pressing *8, and then I will unmute them and they can ask you questions.
Oh, I see. Okay, so that's how it's going to go.
Yeah.
Well, okay. Like I say, I wish I'd had a little more time to prepare a written statement. Probably would have gone a little bit better.
No, we don't like it. We don't like it when people read.
Okay. Well, here we go. Now, I was talking about the Fourth and Fifth Amendment.
Right.
That's the only way criminal charges, what's going on now, that's the only way the criminal charges can be brought under our Constitution. I don't know if everybody understands that or not.
Well, how are they doing it now, then?
And I'm not sure what's going on here. Angela, what's all the noise in the background?
Uh-oh. You got noise in the background?
All the time, yeah.
I don't know. Shouldn't be.
Okay. Well, so anyway, once again, those are the only two ways. But once again, how many people are charged under the Fourth and Fifth Amendment? Virtually nobody. And that's the big rub with the patriot community. How can these guys bring me into a judicial forum and charge me without doing it under the Fourth and Fifth Amendment? Well, the process is relatively simple if you follow exactly what they're doing. Everything in our country, I mean, with very few exceptions, especially here in Washington State, all criminal process is done through statute. Okay. So now, if you have the Fourth and Fifth Amendments, you have all kinds of things you have that they have to. I mean, they have all kinds of things that they must do in order to bring the charge. I mean, you got to have witnesses. You got to have have all kinds of facts and everything, and then the prosecutor's got to get it together, and he's got to lay all this stuff for the judge, and the judge got to make a determination of probable cause. After he makes the determination of probable cause, an arrest warrant is issued. So that's pretty long, laborious, and expensive. And so what they do is they bring, instead of going through all that stuff, they bring the charge under statute. And in order to bring a charge under statute, all they have to do is just write you a citation, hand it to you, and volare, you are in. Well, now, what they will usually do is they will take the cop will take that citation, and he will deliver it to the local district court here in Washington, which is a court of limited jurisdiction. Well, the issue is before the court. The cop has filed the citation, and so if you understand that the court not can handle any charges brought by the state, and you understand that the judge handles or has two hats. And he can set as a judicial officer, or he can set as an administrative officer. And so what they do is they file a ticket into court there. He'll bring you they'll summons you in. They'll say you've been charged, and then they'll say, how do you plead? Well, now if you were to make a plea at that time, you have waived what is known as your administrative remedies. Whenever a statute is brought up, whenever a statute is brought up by citation, you must understand that the statute only addresses issues that has to do with persons, not people. Now, most people don't understand that there is a difference between persons and people, or they don't understand that the legislature cannot pass laws. And I wish there was a question and answer here session so that we could discuss this a little bit. But most people do not understand that our legislature cannot pass laws that affect people, only that which affects persons. If they're going to pass laws that affect the people, they have to amend the Constitution, because the Constitution is already there and the common law is already there, and that's what governs everything. So you have to understand when they pass a statute, it is to regulate persons, not people. Now you wonder, what is the difference between a person and a people? Well, a person is, under the statute, is any person who operates or functions in a regulated activity. So, for instance, if you were, most people out there in the patriot community understand that, that driving is a right, not a privilege. But they always try to claim that when they write you a ticket, that driving is a privilege. And if you read the statutes that they charge you with, it'll always say any person who. Well, here, who is this person? Well, the person that they're talking about is the person that is functioning in a regulated activity. Well, are you functioning in a regulated activity when you drive your car? No, you're not. But if you were driving a truck, if you were driving a taxi, if you were doing something for hire, if you were a jobber going up and down the street, you would be operating the business on the highway, and that is a highly regulated activity. But if you are just traveling in your car, that's not a regulated activity at all. In fact, you have a common law right to travel in your car. And so you can multiply this over and over and over again. Whenever they come after you with a statute, you always have what is known as administrative remedies. In other words, under the Administrative Procedures Act, you can demand a hearing and a declaratory order from that hearing to be issued as to your status before the statute. I don't know if that makes any sense or not. But if you are the statute, if it is to apply to you, and for the administrative agency to have any authority over you, you must be participating in a regulated activity. And so the statute itself must define with particularity who that person is. And so if you are not operating within the parameters of the statute, then the agency has no authority over you. And so all these things happen before you get to the judiciary. These are all the administrative agencies are all set up as an executive part of government. And so the executive agencies are out there to enforce statutes, but they can't enforce the statutes against people. They can only enforce the statute against persons. And I've defined what person is several times here.
Yeah, a lot of times our group is pretty sophisticated. We're pretty smart. We've got a lot of good people in our group. We like to refer to ourselves as men and women, like man or woman. But people is good.
Well, I'll ask you a question now, Angela. Now, can you become a person by functioning in a regulated activity?
Yeah.
You bet you can.
Yeah.
And so, but here's the thing. What exactly they are regulating represents a very, very, very small portion of your life. You understand? But they want you to believe that whatever you do, in other words, if they write you a citation and they charge you under statute, they want you to believe that you are functioning in that. The presumption is that you're functioning in that regulated activity. Like driving, for instance. Are you familiar with the driving issue, Angela? Hello?
Yeah, I'm sorry. I had my mute button on.
Okay. Are you familiar with the driving issue?
Yeah, we are.
Okay, then you understand that you have the right to travel?
Right. Karl Lentz puts it this way. He goes, you have a right to get from point A to point B without interference or, intrusion.
Well, there you go, whether you're driving in a wagon or a car.
Right. Right.
And so that's the issue. Mm-hmm. But most people do not understand exactly what controls the issue. And what controls the issue here is the Administrative Procedures Act. See, all those administrative agencies that come against you and make these charges, they are controlled by procedure, and that procedure is the Administrative Procedures Act. And one of the elements of the Administrative Procedures Act is, if you demand it, you can demand a hearing whereby you can ask them. In fact, they have to prove point blank that somehow, some way, you are participating in a regulated activity before the charge can move forward. And most people don't understand that. Are you? What state are you from, Angela?
I'm in California.
The same thing. California has revised statutes, and it has Administrative Procedures Act. I know. I have a friend down there who's read it, and so all you have to do is just when you are. In other words, this, for instance, if I was given a ticket, and I've been given tickets, several tickets for driving without a license. The first thing that I would do under the statute is I would petition the department head for what is known as an adjudicative hearing. And so when I petition the department head for an adjudicative hearing, he is required under law, and he is under no circumstances to try to bypass that hearing. When I ask for that hearing, he must give it to me. If he does not give it to me, the whole process ends. You understand? Does that make any sense?
Oh, yeah, it makes sense. I don't know if it happens, though.
In other words, if I demand a declaratory order to come out of that hearing, they have to say, okay, this is exactly how you were participating in a privileged activity. Do you know how many times they've told me that they've held the hearing?
Never.
Never. But you understand, if they don't hold the hearing, the whole process ends. Period.
Okay.
Do you understand?
Yes, I do.
Does that make any sense?
Of course.
But most people don't understand this. They think just because somehow, some way, they ended up before the district court judge up there, that somehow, some way, this was converted from an administrative issue to that which is judicial, and nothing could be further from the truth unless you make a plea. Now, whenever I go up to make a plea, I always have my affidavit with me, and when I'm called before the bar, I move on up there, and of course they tell me, you've been charged, and I said, okay, well, if I've been charged, then here's what I'm here. I'm here in order to answer the charge, but I'm not here to make a plea. What I've already done is I show my affidavit to the judge. I tell him what I've already done is I've petitioned the department head, which is the Department of Licensing. I've petitioned them for a hearing to show whether or not I'm a person under the statutes. And at that point in time, once I do that, and once I inform him of that, he is absolutely he's handcuffed. He's all tied. There's nothing else. There's nothing else for me to talk about. There's nothing else for him to do except, okay, we'll see you later if and when the agency ever petitions me to make a ruling on their rulings, and that's about it.
Did you do that with
I've done this time. I've done this time after time after time.
Can you do that with the Franchise Tax Board?
You're going to have to repeat that to me one more time.
Can you do that also with the Franchise Tax Board in California? Here we have
any statutory issue, back to the original proposition, can the legislature pass laws that regulate people? No. They only regulate persons. And so they can only pass statutes that regulate persons in a regulated activity. And if they don't have that, they have the common law, which is the Fourth and Fifth Amendment, if they're going to bring a criminal charge. Does that make any sense?
Absolutely. Let me stop you there for 1 second. Let me just put it out there. Anybody that wants to ask a question, press star 8, and that'll put you in the queue. And that way you'll be ready to ask questions when he's ready to take your questions. All right.
Okay.
*8. All right, everybody should know that by now anyway, that you press *8 to ask a question. All right, go ahead, Merrill. I'm sorry for the interruption.
Okay, well, I thought someone was going to ask a question.
Well, you got to give them a minute.
Okay.
Nobody's got any questions yet, so.
Once you understand, that when a citation is issued under statute, when a statute is broken and a citation is issued, you must understand that at that point you have what is known as administrative remedies. In other words, the ticket that you are given by the officer has nothing to do with the judiciary. It only has to do with the administrative agency that's coming after you. When the cop gives you a ticket for say, driving without a license, the judiciary is not coming after you. The administrative agency is.
Right.
You understand?
Yeah.
Whatever agency, when they pass a statute, like then the Department of Licensing was created in order to enforce the statute that has to deal with driving with or without a license. And so when the cop gives you a ticket, that ticket has no judicial force about it at all. All it is just a notice by the agency that they believe that you are doing something to break to violate the statute. Mm-hmm. And so the principal question at that time would be, okay, if I'm doing something to violate the statute, what regulated activity am I participating in? Right. And so you have the right under the Administrative Procedures Act to demand a hearing. This is all non-judicial. This is all administrative. You have the right to demand a hearing, and you have the right to demand a declaratory order whereby they define exactly what it is that you were doing that they regulate that you didn't have a license to do.
Right, and you have to hold their feet to the fire. You can't let them get off on it. There's a question.
This is the way it's done. You understand?
Sure.
Okay.
You ready for a question?
Oh, you bet.
All right, guest 26, you've been unmuted. Do you have a question for our guest speaker, Merrill Frantz?
Hi, this is Malika. How's everybody
doing? Fine, thank you.
Well,
do you have a question?
Yes, I do. I really appreciate this last bit of information that was given. I wanted to know if how we would find out who would be the head of the department to request the type of hearing.
Okay, so now whatever they put on the ticket, there's got to be some section of the code. Like for instance, now Title 46 governs the licensees under that were issued by the Department of Licensing, and so if you go to the front of Title 46, it should explain exactly who the department head is. Now, my wife might have a comment on this.
Yeah, usually in the definition section of that title at the beginning, it'll define the department. It'll say what the department means for that section.
And then they'll tell you who the department head is. In fact,
you have to look it up online.
Whatever
state you're in, you have to go to that state and find out. Like if it's the Department of Licensing, is what they mean by the department. Then you go to the state website and find out who the head of the Department of Licensing is.
Did you catch that?
Yeah. So it depends on what the statutory claim is on the front of the ticket.
Well, if you were given a ticket for driving without a license, you would go to Title 46.
Okay.
And if you go to the beginning of the title there, it will explain who the department head is and everything, and then you go to their website. Here's my wife.
Well, now that's Title 46 is in Washington State. It depends on what state you are.
Right.
Just look at your ticket,
right.
See what the first couple of numbers are there, and then go to your revised code for your state and find out what title those first two numbers are. Usually it's two numbers. And
there should define who the department head is, and where to find him.
Yeah.
All right. And the second question about this, would a similar procedure work for civil matters? And then if it does, how would one find out, who to make such a hearing to?
Anytime you are given a citation whereby you are charged under statute, this works. Okay?
Yeah, even in a civil matter.
Criminal, civil, as long as there's some kind of citation where you've broken the statute, then you look to the Administrative Procedures Act, and the Administrative Procedures Act governs.
Right, but how would you find out who would be the department head there? I understand with the ticket, you look at the scope. All these citations are broken up into different titles. Right.
Different titles administer different things, and so you got with the Department of Licensing, it's Title 46. With the Department of Revenue, it's Title 88, and so it will tell you on the ticket itself.
Yeah, it'll be probably
the ticket. The first thing that they'll say on the ticket: you have broken such and such a statute under Title blah 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 blah. And all you do is just follow the paper trail there.
It's usually the first two numbers, and there's a period, and then there's some more numbers after that. Well, the first two numbers tell you what title to look for. So
you look to that title, and you look at the numbers under that title. It'll tell you exactly what statute you broke. And then if it is a statute, all you go to 35.04 or 34.05 here in Washington State, and that's the Administrative Procedures Act. Follow directions.
Got it.
Anybody that has, once again though, I've just written a book, and so if anyone has any questions or as to how the process works and how you handle these situations, it's all explained in the book.
Thank you so much.
Thank you. Moving right along, let's see here. Alan Jeffries, you've been unmuted. Do you have a question?
Hi.
Hi.
Hey, Merrill, thank you for being here tonight. As far as getting your book, you'll have that information to Angela so we can find a way to purchase it since it's not online, correct?
Yes, sir.
Yeah,
All
it's
right.
not online yet, anyway.
Yeah, well,
but
one of these days.
He asked if you would have the information, and I most surely by the time this evening ends, she will have all the information.
Do you have your
Awesome.
book on Amazon, Merrill, or?
No, not yet. It just went through the final proofing.
Oh, okay. All
So
right.
we're getting it together. But if you want a copy, I'll make sure you get one.
Okay. Yeah.
Okay.
We can put a link to it, or when you get one, we'll put a link.
Well, my question, Merrill,
go ahead.
is how does you mentioned common law? How does common law interface with this administrative remedy?
Well, actually, there's none. See? When you talk about the common law, you're talking about judicial function. But when you're talking about statutes, you're not talking about judicial function. You're talking about administrative function. Now, how the process works is this.
Merrill, I'm sorry. Could you define? Sorry, before you go on, I want to hear what you have to say. How do you define judicial function?
Judicial function. In our government there's three different great divisions. One is judicial. One is legislative.
Go ahead. Executive.
Okay. So we got legislative, and we got administrative, and we got judicial, right? So that's one of the three main functions of government.
All right.
So whenever there's a process, whenever there must be due process that brings you before the court in any judicial function, whether it's civil or criminal. So if it's civil, it must happen under the Sixth Amendment. If it's criminal, it must happen under the Fourth and Fifth Amendment.
All right.
All those processes are well defined in as many places on the internet that you can number. You understand?
Yes.
So
yes. Okay. Thank you for explaining.
In order for them to function judicially, they must follow that due process to bring you before that forum.
Okay.
Does that make any sense? Okay.
Yeah.
So now, so a ticket has nothing to do, a citation has nothing to do with anything judicial. It's all administrative.
Right.
You understand? What happens here is the statute is passed, the administrative agency is created to enforce the statute. But the statute is only enforced against people who are participating in a regulated activity.
Right.
And so the initial process is there to first determine whether or not you did what they said that you did, and whether you are a person that is operating in a privileged activity. Once they make their determinations, then they ask the judiciary to enforce them. That's how due process works in this country. Of course, now they try to abbreviate that a little bit. They try to move this process along a little faster than that, but that's basically what's happened and what's supposed to happen. That's why when I ask for a hearing and they don't give it, the process stops.
Yeah, and the thing is, maybe that has something to do with, I've heard several people use the Walmart analogy. If I'm an employee of Walmart, then I am a person of Walmart, you might say, where I'm a people that, is navigating that person, but I am, as an employee of Walmart, I have to function under their statutes. And
that's a good analogy, and you're right. As a people, you walk in there, you ask for a job. If they give it to you, you are given those functions, and you become a person that can function in that store.
And what you're saying is, if my breaking a statute happens as a person, as an employee of Walmart, they got jurisdiction. However, if it happens outside of my activities as an employee of Walmart, even though I am an employee, that happened as a people.
You got it.
Okay.
You got the concept. Now, the problem is that most people don't understand this. When they receive a citation and that cop files the citation at the local district court, they think somehow that they're operating in a judicial function, and nothing could be further from the truth. It doesn't become judicial until you make a plea.
Yeah, when I plea, then I'm saying yes, I was under jurisdiction of Walmart when I made the offense, even though I wasn't, because I don't understand. You know what I'm saying?
Well, I mean, you might try to explain it to them that way, but what I'm giving you is the exact process that you should use and follow through with.
Yeah. I'm just trying to paraphrase it.
And once you see, you must, when you're given a citation, you must make an appearance. But you don't have to make it. Isn't necessary that you make an appearance in the court. You can make an appearance by asking the department head for an adjudicated hearing. That's an appearance also.
Yeah. Okay. All right.
Okay.
All right. I guess I'm still trying to get my head around the common law aspect. I mean, that it seemed that was part of Angela's introduction to you, and you did mention that phrase, and I just didn't see how that connected, because this sounds completely administrative.
Well,
using their system.
That's what we're getting at. See, everyone thinks that with all these citations that they're getting, that has something to do with the law. Well, it does, and can, but there's an administrative portion of the situation that first must be clarified as to whether or not you are actually the person that's functioning in that activity.
Yeah.
See,
okay. All right.
The only way that the judiciary gets a hold of it is once the agency itself makes its determinations as to what your status and what you did. Then they ask the judiciary for enforcement. You got to understand, only the judiciary has the police powers. Now, in other words, only the judiciary can take your goods and throw you in jail.
Yeah.
You understand? And the other two functions of government can't do that. And so, since this is the ticket is administrative in nature, none of the administrative agencies have judicial power. So they can't take your money, they can't take your goods, and they can't throw you in jail. They can recommend that you were thrown in jail.
Yeah. Sure, I can volunteer for it. Yeah, I'm the one who puts myself in jail, really, isn't it? I mean, as far as the common law thing.
You hit the nail right on the head. Everybody, 99% of the people in jail are because they volunteered.
Right. Kind of like paying taxes, right?
That sounds so fantastic, but nonetheless, it's true.
Yeah. Well, okay, Merrill. As far as common law, maybe in my mind, what I see as common law is if I cause any harm, injury, or loss to another man or person or people. Okay, and if you go to through this process, administrative process, and they determine yes, you have caused harm, injury, or loss, then that's maybe how you don't get your ticket freed from their jurisdiction. You know what I'm saying?
Well, you have to understand now, if they are saying that you are operating in a privileged activity, see, the person must be defined by the statute. And it can't be any ambiguity.
I know.
It's ambiguous.
Yeah.
It's got to be right on. You got to hit the nail right on the head. In other words, the explanation must define you explicitly. If it doesn't, then the statute is void for vagueness. And so unless they show that you specifically were operating in this privileged activity, they don't have anything to say to you.
Oh, okay. All right.
Let's put in a caveat here, okay?
All right.
You have to understand now. You have to understand how big this whole monstrous process is. I mean, it's you just look at the IRS.
Right.
Look how many millions of dollars it brings in. Just a little. I live in a little county in western Washington called Jefferson County, and it's probably the smallest county in the state. And within that court system there, through this process that we've been discussing, those guys bring in about $3 million a year. Now that's just little Jefferson County. Now you can imagine, like a big county like King County or Pierce County, what they do.
Oh yeah.
This thing is a monster, and just because you bring some of this stuff up, don't think that they're going to say, "Oh wow, we didn't realize this. We're going to roll over for you." They're going to do everything in their power to defeat you. You understand that? Yeah,
and so is that something that you have in your book as far as how to manage your jurisdiction as a people versus
how the people can be free? The administrative process is legitimate.
Right.
I mean, there's nothing the matter with the process. The problem is that we don't understand it. So we don't know how to challenge it.
Right.
But now, after listening to the program tonight, at least you have an inkling of how to challenge it.
Yeah, exactly.
Where before, if you try to challenge, you can challenge it in court. But I mean, when you get all into the district court for like driving without a license, you can challenge it there. But the thing is such a monster. I mean, it'll take you years of appeals and maybe you might even take it. You might even have to go to the Ninth Circuit to get vindicated on the issue. And so it takes money, time, effort, and knowledge. And the whole process is filled with potholes, man. If you get waylaid real easy, and so. But what I'm telling you is this stops it right at the beginning.
It's the Achilles heel of the monster.
You chop the head off right at the starting gate.
Right. Hey, Merrill, thank you for your information. I have to go. Thank you, Angela, for unmuting me, and I'll end my conversation. Thank you, everybody.
Thank you.
Welcome.
All right, next up is Dimit Ripsey? That's a hard one to say. Go ahead. Did you have a question?
Thank you, Angela. Yes, Dimitri. Dimitri.
Oh, okay.
So,
sorry.
what I wanted to ask was, before you were talking about...
I can just, I'm hard hearing, and I can just barely understand what you're saying.
Dimitri, can you speak up louder, please?
Yeah, sure. Is that better now? Is that
That's
better? Hello?
Yeah.
Better, right. So what I wanted to ask was, by you signing that piece of plastic, namely the driving license, wouldn't that put you under some sort of jurisdiction, you know?
When you are driving, in other words, when the roads have two uses. One is ordinary and one is extraordinary. The ordinary use of the road allows you to travel back and forth unimpeded under the common law. The extraordinary use comes in when you start using the roadway as a place of business. When you start using the roadway as a place of business, a license is required. Does that answer your question?
Right.
Okay, so
yeah,
now,
it does.
if I'm driving a taxi, I need to have a license. You understand? This all involves the public, and so I need to have a license. And if I don't have a license, then they can sanction me and they can throw me in jail and a bunch of things they can do.
Okay, but
if
Merrill,
I'm not driving, but if I'm just traveling up and down the road, only thing that regulates me is the common law. Go ahead.
okay, but what if you are, let's say you have a truck, you know, a little mid-sized truck, and you help people move every day, and you charge them, you know, $10 an hour or whatever, but that's still your business. That's still you.
That's jobbing, but not what I would recommend is that you don't tell anybody.
Yeah, well, but that's what I mean. It's not the same thing as running a business.
You have a private contract there. You don't have to tell anybody.
Right. Exactly.
And if they can't prove it, see, when they start calling you, they start charging you as being a driver, when they start charging you as being a driver, they have to prove it. You understand? They have to show bills of lading, something, you know. And so go ahead.
Go ahead, Dimitri. Did you have anything else?
Yeah. Yeah, well, so like here at Australia where I'm at, they give you the option to have a commercial license or you can have a private license. So when you have a private license, it almost sounds a bit like that you're operating this property, this vehicle, for your own private sake, for your own private life, but it's almost like you're still under some sort of jurisdiction, even though it's a private matter. So it's confusing, isn't it?
Right. I think the point is not to ask for a license, right? Don't ask permission.
No, here's the thing. Hey, man. How you been? When if you are charged with anything on the highway,
oh boy,
you must be participating. See, just because you have the license, that doesn't mean that you're using it.
Right.
Does that make any sense?
Because Karl Lentz mentioned that...
If you're in a big rig and you're driving up and down the road, the presumption is that you have a CDL and that you're using that to do whatever needs to be done, right? But just because you have a CDL and you're driving along in your car, that doesn't mean that you're using the CDL at that time, right? See, you have to actually be participating in the privileged activity, and if you're not, well, then you know. Once again, they're supposed to prove that. But if you understand how to demand an adjudicative hearing and demand a declaratory order come out of that, declaring your status before the agency and the statute, then you understand the problem that they have.
Have you done this, Merrill, and succeeded at it?
Myriad times.
Oh, I love that.
I mean, you know, and it works like a shot. And this is what I really like, Angela. This is the way that it's done, and this is the way that people have been, you know, hammered for so long. I mean, because they're hammered because they don't know the proper process. They don't understand what administrative process is. They don't understand that they can participate or have to participate or can participate. They just presume that once that ticket gets into court up there, that there's some kind of judicial function connected to it, and that they're forced to go in there and deal with it. Nothing could be further from the truth. Once they make the plea, though, once they make the plea in the district court, basically what you've done at that time is you waived all of your administrative remedies. And now you got to go forward with what the court has to say, and the only way out of the district court after you make a plea is through appeal. Good luck with that.
Yeah.
Does this make any sense? I mean, I've been in this spring for a long time. I spent time in jail over these issues, and I've seen some of my friends do the same thing. But if they would have known what I know now, as far as to exactly what process they are in, and there's nothing more than executive administrative process, and that the Administrative Procedures Act controls everything that happens once you get the citation. Once they understand that, it's the rest is simple. It's easy. Like I said,
so as long as you
just a second, Merrill.
So as long as you notice.
Go ahead, Dimitri.
So as long as you notice the court, and as long as you notice the prosecutor and basically everybody in the matter, that you were not operating under that piece of plastic, and that you were just minding your own private life as a private man, then there shouldn't be any problem, right?
Well, you have to understand that in order to have to talk to the prosecutor, have to talk to him, he has to bring forth certain processes from the court. You understand? In other words, it is up to the prosecutor. He represents the people. And if you've broken the law, it's up to him to assemble all the facts regarding the situation and establish what is known as the subject matter. Now, for instance, under the Fourth Amendment, if he is to issue process under the Fourth Amendment, someone has to come to him with an affidavit stating that somehow, some way, someone purposely injured him. You understand? In other words, in order for the Fourth Amendment to operate, someone has to come forth with an affidavit saying, this guy come up to me and he punched me in the head without provocation. Okay, what he just said was that this guy on purpose come up and hit me and purposely damaged me. That's called the element of mens rea. He takes that affidavit to the prosecutor. The prosecutor takes it to the judge. The judge sees the affidavit, and the judge says, "Okay, I find probable cause that a crime has taken place here. Someone has assaulted someone, and they arrest you and bring you before the court and make you answer the charge." That's how it works. If the prosecutor under the Fourth Amendment didn't have that affidavit, there's nothing for him to work with. You understand? Mm-hmm. And if nothing was brought to him brought before the judge has nothing to say to you. You understand? Mm-hmm. And so if you receive a citation, this is just some kind of witness by the state that they believe somehow, maybe perhaps, that you have broken one of their rules. Now, the Administrative Procedures Act says that before they can come forward and make their findings, the first thing that you can demand is a hearing and a declaratory order, and let them define exactly what it is that you did that they thought was a regulated activity. And if they can't discover anything that you did that was a regulated activity, they got nothing more to say to you.
So would that be in writing to the prosecutor?
They have nothing to say to you. They have nothing to say to you. That's it. That's how it works. This is our system of government.
Yeah.
See, the legislature absolutely cannot pass laws that govern people, only persons. You understand? And those persons must be defined as operating in a privileged activity. In other words, like the driver's issue we've been discussing. So I hope this makes sense to you. If it don't make sense to you, buy the book.
No.
It's all explained in there.
You have all this in your book?
Much better than I'm doing here tonight. I'm a little nervous, and so I'm not getting everything out as well as I possibly could. But you got another question or anything?
You're doing fine. What else, Dimitri? Did you have anything else?
Yeah, I do one more thing to ask. Yeah, that is that if I can I go at the court as a person, knowingly that at the same time I'm also a man, right? And everybody can see and knows that I am a man of flesh and blood. So could I go at the court as a person and accept their charge, and then, at the same time, that would basically, they would have to therefore accept my claim against them now. Is that possible? Because I think Karl mentioned something like this.
Okay, Angela, are you there?
Yeah, I'm here.
Okay, could you interpret that for me? I'm not picking everything he says, but I can hear you clearly.
He said if he goes into a court as a person and accepts the charge, I don't understand why you would do that, Dimitri.
Oh, because
you don't
then
need
you come
to do
across
that.
more polite or something.
Speak up a little louder so he can hear you.
Right.
He's all the way in Australia, Merrill. So.
It's a long way.
Well,
it's a long way.
You have to shout louder, so.
Yell.
Yes, like the reason why I want to do that is because I don't want to come across arrogant, but I disrespect the rules of society that I'm living at. So I want to come across as, guys, I'm trying to, like, my best respect your rules, but look, at the same time, I'm also a man.
Well, but you can't be. I don't think you want to be both. What are they charging you with, first of all, if you don't mind?
Well, it's just that I was told by the motor registry that I can start driving on a certain day, and they were off by one day. So I was just using my car, and this cop pulls me over and tells me, "Mate, you got no license, you're suspended." I'm like, that can't be right, because they told me that I can drive. And anyway, I didn't have it in a written form. It was a verbal conversation that I had with somebody. And anyway, it turns out that they gave me a court notice about this. So it's just driving whilst being suspended, they say.
I don't know. What would he do, Merrill?
Well, I'm not entirely sure exactly,
I guess
what he's asked, but I can say this.
He had a suspended license, and the court told him he could start driving again on such and such a date.
No, it wasn't a court. It wasn't a court. It was a motor registry personnel. When I asked her when I can drive again, she accidentally gave me 1 day too early. If that makes sense.
Okay.
So they told me Monday.
His driver's license was suspended. It was reinstated by the court, but this particular officer had not received notice of that. And so that should be a really, really easy, simple thing to clear up. Just bring the notice back to the court and tell them what happened, and everything should be dismissed.
Well, there was no court. There was no court involved in this, or a court notice. It was just a verbal conversation. I verbally spoke to this lady at the motor registry, and she told me I can start driving again on Monday, but she made a mistake. She should have said to me Tuesday, not Monday. And so the cop pulled me over and told me, "Mate, you shouldn't be driving today. You can drive tomorrow, but not today." And hence he gave me a court notice to go to court, because they are claiming that I don't know, whatever, driving without a license. So there was no court involved in this dealing.
The lady gave you the okay to drive that she must have given you some kind of written authorization.
No, it wasn't written. It was verbal.
It sounds
verbally.
more like
Okay.
understanding.
Well, I don't want to tell you there. Just go back to court and explain what happened. Hopefully they'll see it your way.
Yeah, it's just a misunderstanding, and I think
Yeah.
you can probably clear that up, right?
Yeah.
Yeah, just
So
by
it could have been governed there
Well,
as a person, maybe.
It's always from Aussie land, you know. Anyway, go ahead, Angela. You got anything else?
Well, I was just saying, I think that they'd straighten that out. I mean, it's just a misunderstanding. If he explains it to them the way he just explained it now, they should.
I would understand if I was the judge, you know.
Yeah, I mean, one day, are they going to be that, you know?
Okay.
Crazy.
Well, thank you for that. I don't know.
I don't know if you would. Why? Would you wanted to go back in as a man and make a claim?
Well, what I was thinking
the only thing that needs to be done is just go to the court, back to the court, and explain what happened, and let them make the determination.
Right. But what were you going to say, Dimitri?
I was going to say that I was hoping to just go in there as a person, and if they try to like say, oh, listen, you have to pay now all this money, that's when I wanted to change into being a man, if that's possible to do.
I see. Well,
yeah,
anything's possible.
Mm-hmm.
I'm not entirely sure what the question is. Are you, Angela?
Well, I was trying to find out. I guess you're worried that they're going to fine you a large amount of money.
Yeah, because it's like it's
for one
it's like
day for
$3,500.
Hey, if you go in there and say, look, the lady at the DMV, the vehicle registration told me I can go start driving on Monday. You know, when I spoke to her, do you know who she is? Do you have her name?
Well,
was
she
it on
wouldn't
the phone
give me her
or
name.
in person? Oh.
Well,
but was it in person or?
It was in person. It was in person, yes.
So you can identify her if you had to.
Yes, I can.
That's all you got to say in court is I can identify her if I go in there. You know.
I did go in there, but then the manager wouldn't let me speak to her, and the manager said that the manager spoke to her, and she got back to me, and she said that she never told me Monday, so like they were kind of lying to me the second time that I went there, you know, being difficult.
Well, it's your word against hers. I mean, what are they going to squabble over one day? Are they that unreasonable? Exactly. I mean, really, that's. It's not
reasonable. It's not. Yeah, but the black and white letter of the law says that I should be penalized. That's the problem. See?
Okay, but it's not like you were, deliberately doing it to break the law. You went out there driving because this woman told you to go back. You could start driving on Monday. If she didn't tell you that, you would have waited till Tuesday, right?
Right, of course.
So, I mean, it doesn't make any sense for them. Well, I mean, but then none of them make sense, do they? They're all criminals. So, I don't know.
Yeah.
I just tried to go in there and explain, that there was a misunderstanding,
Yeah, I think I will. So can I just ask one more question?
Sure.
If I do go in there as a person and I plead whatever I plead, and it turns out that I gotta pay some money, what if I then just send an invoice, a bill, to the policeman who stopped me and gave me 3 orders? Because I actually did say to the policeman that I do charge for the orders that I receive, and I explained to him how I wasn't driving, I was going from point A to point B, and perhaps he can pay for the fine. I can give him a bill.
Yeah, that's what Karl would do.
But then the question is, if I do go to the court now as a person, then how on earth am I going to bill this?
Don't go as a person. Just say,
I
am a man. If you refer to yourself, I am a man. Blah. Don't admit to their claim that you're a person. You're not.
But how can I go in there? But how can I go in there as a man and also plea at the same time?
Well, you're not going to plead anything. You're going to explain there was a misunderstanding, right? You're not going to plead to anything. You know, you have a right to go from point A to point B. You went along with this, I don't know. Maybe you should talk to Karl. I don't know. I don't know. Yeah, because that's what PJ is saying on the chat here. Show the injured party or the harmed party. Who was harmed by all of this? Nobody.
Well, obviously nobody.
Let me explain something, Angela. The issue has already been decided. You understand? It's already decided that his license should be suspended. That's not the issue now.
Okay.
It's already determined that he's a person under the statute. His license was suspended, but it was reinstated. The only thing he has to do now is go back down to the judge, explain that the lady there at the DMV said it was okay for him to drive on Monday, and that he got a ticket there by the officer, but the officer was mistaken in giving him the ticket, and let the judge decide. Does that make any sense?
Right.
Are you still there?
Yeah. I'm still here.
Nod your head if you're still there.
Yeah, we're all still here.
Okay. Okay, so just explain it to him, and like I say, the issue was already decided. Now it's just a matter of whether or not he's gonna whether the lady's gonna cop out as to what she said or what she didn't say. And so good luck, and here we go.
Okay, thanks for that, then. All right.
All right, thank you, Dimitri.
Thank you, guys. See you later. Bye.
Okay. Anybody else have a question? Press *8. Otherwise, Karl's on. Hi, Karl. Do you know Karl Lentz, Merrill?
I know a Lentz, but his name isn't Karl.
Oh, you'd like him. You'd get along with him really good, I think. You think the same way, on the same wavelengths.
On the same wavelength? Say something, Karl.
Well, he's not been unmuted. I don't know if he wants to say anything. He might be just wanting to listen. He didn't put his hand up, so. Karl, you want to talk? Hey, you've been unmuted.
Just driving down the road right now. Yeah, I kind of figured you might hear too much road noise if I talk.
No, you won't. We don't. We don't hear the road at all. You're coming in loud and clear. Yeah, let me ask you something though. Did you hear the gentleman from Australia, Dimitri, was talking about his situation?
Who, me? Did I hear anything from Australia?
Yeah.
No, I just logged on about 2-3 minutes ago.
Oh, he got a ticket. I guess they suspended his license, and he was told he could start driving again on Monday by a late vehicle registration. However, he drove on Monday, and a cop pulled him over and said he wasn't supposed to drive until Tuesday. And now he has to show up in court. They're trying to, over $3,000 in fines and penalties and whatever. And so, what would you do in a situation like that?
Well, what's the guest name tonight?
The guest tonight is Merrill Frantz.
Okay.
You know
what did he say to do?
I'm here.
There he is. Well, he said pretty much what I said, is to go in and explain that the lady at the vehicle registration told you could go on Monday. And if you would have known it was Tuesday, you certainly wouldn't have drove. You would have, just to get through it, not get penalized, explain there was a misunderstanding. How would you handle it?
Yeah, most times they would understand something that simple, especially if he has some sort of a receipt saying that he went and he paid some sort of a fine. Why was his license suspended?
I don't know. Dimitri, why was your license suspended? Wait, let me find him. Hold on a second.
Yeah, it's usually a good question to ask before you start giving him advice.
There you are. Why was your license suspended, Dimitri? Seatbelt.
Thank you.
Go ahead. You've been unmuted. Say it again.
Yes.
Yeah, well, see, that's what I'm saying. Before you give somebody an opinion or advice, it's usually a really good idea to find out why they were arrested or why their license was suspended or why they don't have their children before you start. If this guy said, well, it was vehicular manslaughter and I, was drunk and I ran over a busload of kids, then obviously I'm thinking, my opinion of what he should do is going to be a lot different than a seatbelt.
Yeah, so the
violation.
seatbelt thing, he said it wasn't a ticket, it was a court notice. I got no fine, and I haven't done this before.
But all I'm saying is before I help anybody, the first question I ask them is like, why was it suspended in the first place? So you folks should, you got to be careful when you give people, advice and stuff like that, because what happens is like, well, I'm a mass murderer, and, and they just let me on a roll.
Oh, we knew it was related to the ticket or to a violation of the vehicle
Right,
code.
but that's what I'm saying. He's right, saying that he didn't have a whatever. But like I said, you've got to make sure, that maybe he's a drunk driver. Maybe he has no insurance, and like King Clifford, he never had insurance. And
yeah, but you know what? That doesn't matter because the point is, he did. They suspended him, whatever, and. He was told he can go drive on Monday, but it really wasn't until Tuesday, and that's the situation. And the cop, I don't know, did he give you a ticket, Dimitri, or did he just tell you verbally?
No ticket.
So you just got a notice from the court to show up now because of that.
Okay, that's what I'm saying. It's just confusing. I said the officer didn't give him a citation. Then how was it reported with motor vehicles that he encountered this police officer at all? How did they know?
How did they know?
The cop on the scene gave me a court notice on the very scene, right? Like there.
Oh, a court notice. That's what it was.
Yeah.
Okay.
So he was to appear in court at a certain day at a certain time?
Yeah.
Is that
that's right.
Let's see if that's what I just want to hear what his answer is. So you were given a court notice, and you were told to appear on a certain day on a certain time.
Correct.
And you didn't appear?
No. The court is on the 24th of June. It's coming up, and I've just been studying a common law and such things for the past year now, and I thought maybe I'll put it to practice.
Okay. Angela, what did he kind of say? I mean, it's kind of hard for me to hear him. What did he say?
He said that he has been studying common law for about a year now, and he wanted to put it to practice.
Oh, and all he's got to do is just say, all he has to do is say, at the time of the stop, at the time of that he encountered this police officer, he was not operating under the license, that he was just a man going from point A to point B with his property. And that he carries a driver's license for the ease and convenience of the public officer to identify him. That he's not a known felon or not some baby raper, that he's not. He uses it just merely for the convenience of identification purposes only. Not to take his property from point A to point B with. He doesn't, there's no requirement for a man to have a driver's license to take his property from point A to point B. But he keeps the public document for ease and convenience of identification purposes only for the public police officer. So if he wants to try a common law thing, go ahead, do that one. That's simple.
Right, thanks for that. They might though.
Of course, it's a good answer. I gave it, man.
Wait a minute, one at a time.
Well, they might if I give that answer, they might still turn around and say, oh. Then why did you get the license and sign this document and you signed this contract or whatever? They might,
What do you mean?
Try to say that I'm bound by them.
Angela,
they might try to convince me.
He's saying that what if they say, well, you applied for this license, why did you do that to begin with, type of thing?
I applied for the license. I told you why. I said it's for ease and convenience of identification purposes only. And so when a public officer would like to know who I am and what am I doing in that area, it's for ease of identification purposes only, to show that I'm not a known felon or that I'm not a it's for ease of because, like I said, before driver's license, all you got to do is watch the old Andy Griffith show. And if they didn't recognize the man coming through town, and the man was speeding or the man did whatever, got out of the wrong side of the car, they would hold him. They would hold him until somebody could come forth and identify him, because they didn't know some serial killer was driving through Mayberry, and they weren't going to just let this stranger, this guest, go through their town without knowing what his intents are.
Okay, so a license for identification purposes.
It was very time-consuming at one time in history for you to go into another town from point A to point B until somebody spoke up for you, and somebody would put up a bond for you, or somebody would say, oh, I know who he is. He's okay. You could let him into this castle, or you could let the drawbridge down, or let him into our town. So now,
hold on a second.
It's instant identification check. It's free that we got a piece of plastic. People don't realize, go back 50, 60, 70, 100 years, 1,000 years, and realize just how hard it was for people to identify when a stranger was coming through their land, and how dangerous it was to just let strangers come through and not knowing who they were.
Okay, hold on a second, Karl. Merrill, go ahead. You wanted to make a comment?
Well, I was, I'm not. We've passed through so many issues here. I was just now I'm going to have to ask what the issue is again. Once again, if they're going to issue a citation, you must be operating within the privileged activities that they regulate. It doesn't matter whether you have a license, whether you don't have a license. If you're not participating in the license function, it doesn't matter. Right. Does that make any sense? I mean, I from time to time I have a license for identification purposes also, but I'm not. Unless I'm participating in the licensed activity, it doesn't matter.
Okay, then let me put it this way. So say you don't want to play the statute game, God bless you, no problem. You go speeding through a town, the policeman will arrest you because you breached the peace.
Well, you
breached the peace. So you got two choices.
If you go speeding through town, this is what is known as reckless endangerment. This is common law.
Let me explain.
If you're a threat to the health, safety, and welfare of the public, you understand? If you're doing something that is threatening people and the cop sees you, he has probable cause to stop you and do whatever is necessary, to keep you from hurting people.
So you got two choices. You can take this.
We're talking about licensed activity.
So you got two choices. You can take the citation and promise to appear in the future, or he'll arrest you because he's doing it because the people of that land hired him, paid him to secure and protect their land. So the common law is
of health, safety, and welfare, and you're speeding. That is reckless endangerment. That is a common law issue. We're not talking about common law issues. We're talking about things that require licensure. Okay, and we're talking about those people charging you under statute.
Okay, so you got two choices. One more time. You could accept the charges under statute, or you could accept the common beliefs of the people that if you are doing something reckless in the public, you are going straight to jail.
The cop has discretion to arrest you if you are endangering the health, safety, and welfare of the public. That's common law. We're not talking about common law here. We're talking about statute law and the requirement for licensure. Do you understand?
Yeah, what I'm trying to explain to you, you can either play the common law approach and go to jail, or you can play the statute approach and take the citation and go on with your day.
Okay, well, now, if they charge you under statute, now you have the remedies that I'm telling you about.
What remedy?
So now, once again, it's up to them to choose how they're going to charge you. But if they charge you under statute, now you have the remedies under the Administrative Procedures Act.
Okay, so what's the remedy under statute?
If they charge you under statute, you have a remedy under the Administrative Procedures Act. They must prove that you're a person, and there is no judicial. There's no police powers connected to it. If they tried to apply the police powers to it, they violated due process.
So what you're going to try to do is you're going to accept the statute citation, and then you're going to jump back into common law and act like a man?
Once again, if they arrest you because you had a tail light out, it's a false arrest.
How's it a false arrest?
Yeah, there's no injured party.
They can't arrest you for having a tail light out. Come on.
Oh, tell me the last time you've heard. Tell me no. Tell me the last time you. Tell me. Just give me one person that ever got arrested for having a tail light out. Just tell me one man you know. One name.
Me.
Who?
Yeah, he said me.
Who? What man ever got arrested for having a tail light out?
Merrill said.
My goodness.
I've never heard of anybody get arrested.
I use up all my fingers and toes. I'm not kidding you. They do some
just give me a name of just one person who got arrested for having a tail light out.
Okay, what's his name down there that worked here on my boat? What's his name?
Dave McMillan.
Dave McMillan. Yep.
What's his name?
Dave McMillan.
Now, he doesn't mean anything to you. You can either accept my word for it or not. It doesn't matter. We're just talking on a talk show. We don't want to get too far and deep into the situation. But nonetheless, we're discussing what the law means and what it doesn't mean. Okay.
I'm saying it's an inflammatory statement to make a statement saying that the police officers are running around out here arresting people for not having a tail light. That's inflammatory. That's just inciting, panic. No, they're not.
Do you watch TV? Do you watch TV?
What's that?
Sir, do you watch TV?
Yes, sometimes. Yeah, why?
Do you understand what this happened in Baltimore?
No, what happened in Baltimore?
Thank God. Thank God.
His name was Ray, and they killed him on the way to the police station, and it was for a real innocuous thing. It's not identifying himself or something.
Okay, so if you actually know the whole story, do you realize that the prosecutor, the DA for Baltimore, that black lady, do you realize that she wrote a memo for the cops to specifically patrol that street corner and do everything within their power? No. Did you read the statement that came out last night?
Let's back up a little bit, okay? We're talking about issues of law. That's what we're discussing. We're not discussing anything else. We're talking about what the law means, what they can do legally, what they can't do. That's all we're discussing. Okay? And so above and beyond that, I don't know what else to say.
So sir, it's so simple. If you're out in the public and certain societies require you to wear clothing, you wear it. Certain societies like Fiji that don't require you don't. So like I said, when you decide to come out of the public, sir, let me just finish. When you decide,
one of us is going to have to hang up if we don't listen to one another. We're talking about the law, what they're supposed to do under the law, and what they're not. If you're running around out here, and that's called a public nuisance. That's common law. You understand? We're not talking about the common law. We're talking about the difference between the common law and statutes. How they charge you, how they don't charge you. Now, if they charge you under statute, we're showing you an easy way to deal with statutory charges. And almost all charges are statutory. Almost all of them. And so, when you bump into them, this is how you deal with it, and deal with it easily. Okay.
Okay.
So now, if you're going to go speeding, run around naked, all that stuff, you probably get arrested. I'm not against that, but this is what we're discussing. And so, if there's an issue that has to do with statutory enforcement, I'm here to discuss it with you.
All right, California, you've been unmuted. Do you have a question or a comment?
Yes, I do, Angela.
Hi, Dallas.
Hi, how are you?
Fine, thank you.
Hi.
How are you?
Doing real good. And I haven't said hi to Carl in a long time. How you doing, Carl?
Carl, I had to mute him out.
Oh, okay, good. All right, because
I love you, Karl, but you're getting argumentative.
That's the one thing I was going to ask you. I was going to say, I love Karl. I love all this stuff, and I watch and listen to all the time. But I need to ask Merril a question for some things. he's the guest speaker here, and I just to make a comment first before I ask my questions. I listen to everyone, and everyone has a different way of doing whatever they do. And one may argue with the other one back and forth because they have different ways of doing it. But my thing is, I don't care who does what. Karl does his thing, and there's things I use that Karl does. Other people I'm listening. For the first time, I'm listening to Robert Fox, and there's some things that Robert Fox does that's very interesting. And from that, I guess the talk she had back in 2011, because I didn't know who Robert Fox was, and that was the first time I got to listen to him when I listened to the archive. And I'm listening to Merril. There's some things that he's saying that are very interesting and very accurate. And I look at things, whatever works for me to get me in, get me out, and get me to go home, I don't care which method I use. As long as it works and I get to go home. You know, I haven't had a driver license since 1993. I haven't done income tax returns in over 31 years. You know, whatever. And I'm still at home. I'm still here. And I like what Karl said, and some of the other people say, and I have an ID. I have a California ID, but it's not a driver license. And I've used that already when they stopped me twice in the same day. I handed it to them and I say, here, use this. Yeah, you have a driver license. Here, use this. They looked at it both times in the same day, in the morning and in the evening. They let me go. Okay, they let me go. I mean, I've signed it a certain way. I filled out the application a certain way, whatever. I don't know if that's what it was. I have no clue what it was, but they let me go. I don't care what it takes. Whatever it takes, and they let me go, and I get to go home, and I'm safe at home, that's fine with me, whatever method works. The one thing I know is, like you say, Angela, I know who I am and what I am. And because I know who I am and what I am, whatever method I use that works for me, I already know who I am. And a question I have for Merril, okay, is this. I use a lot of the administrative remedies, quite a bit, okay? And I don't use them for me. I use them against the administrators because they have to obey it. It's rules that are meant for them. And if I know certain, I don't have to know everything about the administrative rules, just enough that what I need to use it for, I use it and they leave me alone. I go home and I'm fine. But the question I have regarding, you were talking about driver licenses. You're talking about having, was that an adjudicated hearing? And going in, if someone had a traffic ticket and they went into court and things happened, but they never entered a plea, but they ended up leaving and the court entered a deemed plea in the case. And it's recorded on record that it was a deemed plea, and deemed creates a legal fiction is what it does. That's all deemed does. It's in Black's Law Dictionary. It just creates a legal fiction of something that doesn't exist, that they make it exist. And I've been arrested a few times, and I know how they lie. No matter if you use common law, statutory law, whatever kind of law you use, they'll still lie. They will still lie. And I knew someone who worked in one of the courts in the administrative office. She went to school with my sister, and she told me a lot of the stuff that they did behind the scenes when I was doing things years ago, and explained to me. But I've known a lot of different people. I've known judges. I have relatives who are cops. I have relatives who are attorneys. All that kind of stuff. I hear all of the stuff that goes on. But my question to Merril, because you're looking at the Administrative Procedures Act, and I use it both federally and state of California, which is in the government code, starting at section 11340, I think it is, the California government code. But in that government code, it actually tells you in section 12.5 that they no longer deal with man or men anymore. That code only deals, their California codes only deal with person or persons, and it's stated right in there, section 12.5 in the California government code. And that it's declaratory. It didn't amend anything. It just, they said, hey, everything here refers to persons only. So what you're saying is accurate. If someone has gone into court for a traffic ticket, but they never ever entered a plea, like you said, once the plea is entered, it becomes judicial at that point. But since a plea was never entered, but they entered a deemed presumed plea, it's bizarre what was put on the record, is that still, let's say you're in Washington where you are, and that happened, is that still considered still administrative at that point and not judicial yet? In order to do an adjudicated hearing.
Did you understand what the question?
Yeah.
It was just long what I've been trying
okay,
to do.
what it is, it's me. Okay, when I go into court.
Speak up, Dallas.
When I go into court, I will test things out, okay, to see what works and what doesn't. I have my own way, different than yours, different than Karl's, that I use, and it works for me every single time when I go. And I walk out, and it's fine. What I do, most people probably will never do, but it works for me. And but I went in and tested something out to kind of see how it would work and what would work because of something that happened to me when I did get a traffic ticket. It was a moving violation. And when I went to the court, I didn't see the commissioner. I didn't stipulate. I went directly to the judge with a court of record. So there was a court record that I could get a transcript of. So I could force the judge to say things on the record that they don't like saying, and have them administratively back away and let me alone. And but I was testing something out, and it didn't work, and it backfired on me. And they ended up putting a fine on me and putting and he entered a deemed plea, is what it said, D-E-E-M-E-D, deemed plea, which means that it really doesn't exist, but we'll just presume that it does. We'll create it as though it did exist. And they put a warrant out for my arrest.
Presume that the plea was made, that's what he's saying.
What's that?
They're putting in a plea for you, probably.
Yeah.
They were putting one in for me, but he said he could.
Presuming, see, here's the thing. Once the citation is issued, you must make an appearance. You see? But now the thing is, when they take you into court, you don't have to make the appearance there. If I was to make an appearance to make a plea, I just flush myself down the toilet. You understand?
Mm-hmm.
But when I go before the judge, I give them an affidavit saying, "Hey, I'm not here to make a plea. I have already made my appearance before the agency, and I have petitioned the department head for an adjudicated hearing."
Now that's if you did that. But what if you did do that?
Listen to me now. And now I've complied with everything in the law. I've made my appearance. What is the judge going to say? I know they always told me, "Well, goodbye. We'll see you later, sometime maybe." That was it.
Now that's if you made that appearance for the adjudicated hearing. What if you didn't do that and you went into the court?
Well, you see, the thing is, you have to make an appearance somewhere. Now when he talked about that deemed plea, he's making a plea for you. Did you object? What did you say?
He never said he was making a plea. He never ever said he was entering a plea. He never said it. Okay. As a matter of fact, he looked at the ID card I had, the California ID. He said, "Oh, this looks like a driver license to me." He declared it to be a driver license. If you stand mute, silence is always consent. It's absent, yes, and I didn't stand mute. I was asking him questions all the time.
If he made the plea for you and you didn't object, you have to object in such a way that it complies with the law.
He never verbally entered a plea. That's the whole point.
You received a citation. The law requires for you to make an appearance there before the agency.
Well, the one thing they said was which is interesting with this case, is he put out a warrant for my arrest. The reason why I put it out, failure to appear.
This is the next infamous thing we would discuss, and I knew we'd get around to it sometime tonight. What is the difference between a bench warrant and an arrest warrant? Now, if you don't know, it doesn't matter. I'll explain it, okay?
Okay, go ahead and explain.
The arrest warrant is issued when due process is followed under the 4th and 5th Amendment. A bench warrant is issued to make someone who has been subpoenaed to make them appear before the court. And by the way, the bench warrant must also have an affidavit with it also. And if you want to learn about all this stuff, go to Corpus Juris Secundum and look up bench warrant. I looked it up.
Okay, so
And
okay.
So the thing is now, as far as the bench warrant is concerned, they have been abusing that process from time immemorial. And if they used one against you and you were not subpoenaed, they violated due process. Okay.
Okay.
And there's no issue. What corpus juris says here is that when they issue that bench warrant, there has to be actually due process in place under the Fourth and Fifth Amendment in order for them to issue it, or under the Sixth Amendment.
Yeah. See, I knew nothing about it. I knew nothing about it until I called to see about getting information as to what the status of the ticket was, and the court clerk told me, "Oh, there's a warrant for your arrest over here." And I'm like,
sure.
"Yeah, I didn't know about that. I was never noticed."
Well, sure, they issue a bench warrant. So you didn't appear.
Okay, so since I didn't appear, then there was no appearance, correct? So then the adjudicated hearing can be held? Since they say that I didn't appear?
If you ask for the adjudicated hearing, what you're telling the judge is, hey, I've made my appearance before the agency. You understand? I just petitioned for an adjudicated hearing. That's my appearance.
I didn't do that. So since I didn't do that, what I'm saying is since I did not do request an appearance before the administrative hearing, because there's administrative hearings here. I've been through administrative hearings for other things, but I didn't request that. Okay, I went right into court. So since I did not request that, you're saying I didn't appear, does that mean that I still have it available?
Dallas, let Merrill speak a second. Go ahead, Merrill.
So the judge is saying now you didn't do all these things. You're silent on all your administrative remedies, and so you're here. And so I can represent the agency here. So I'm going to issue a bench warrant and force your appearance here. That's what he did.
Oh.
And if he ever got caught at it, they'd just slap his hand and move on. But nonetheless, if he issued a bench warrant under those conditions, he was violating due process. No two ways about it.
Okay, it gives me something to work.
In fact, if you want to catch him, you want to issue there to Title 42 these guys. That's a good one.
That's a good one then, right?
Yep.
Okay.
Mm-hmm.
Interesting. Okay, just kind of wanted to get your feedback on that situation and how that would work. And how, because it was really strange what happened. Anytime I go in the court, strange things happen anyway. Because I never go through their normal process. I'm always testing stuff out.
They don't have due process. In fact, all the judgments that they come up with, they never have subject matter. You got to understand now. There's no way to bring a criminal charge except under the Fourth and Fifth Amendment. So anything that has to do with a statutory issue is all civil in nature, and the only way that it can be enforced is through civil contempt, not through criminal charges. But you understand that when you see the enormity of that, you'll understand how much this process has been abused, and how much people don't know. It's absolutely amazing.
Yeah, it's kind of interesting to hear your viewpoint.
All these district courts up here, there's not one of them that has subject matter. Therefore, they're all void. All the judgments of them are void, almost totally. If they're without subject matter, there can't be a plea. There can't be anything without subject matter. And if they bring you to the court on a statutory matter, there's no way a subject matter can be established under the Fourth or Fifth Amendment. It has to be, all those things must be enforced through civil contempt. And
then we just volunteer in.
My goodness. Yeah. Start whistling and thinking about it. This is the enormity of the situation. I mean, it's flabbergasting, and it's flabbergasting how much they're supported in what they do. It's because most of the reason because people don't know.
Now, will you be giving Angela some information that she could put on her website as to some of the things you do and how you look at, how you view the Washington Revised Codes in regards to the different sections that you use specifically for what you do out there?
It's this is, we're talking about the difference between what they do, how they bring charges, and how charges are brought under the Fourth and Fifth Amendment, and that's the only place, the only way criminal charges can be brought is under the Fourth and Fifth Amendment. And so anything that they bring up statutorily can only be enforced through civil contempt. You understand? But they convert these things to criminal issues all the time. Where are you from?
Here in California.
I'm in California.
California. Well, they do just about the same thing in California. Not much different. Up in Washington here, they have a district court. They bring you in there, and they say you've been charged. And if you make a plea, you're off and running. But I tell you what, the only thing that they acquire when you make the plea is personam. They can never establish subject matter because it wasn't done on a criminal issue. They can never establish subject matter because it never went through the Fourth and Fifth Amendment. And so, but they pronounce sentence, throw people in jail all the time.
Yeah, what you're saying is is true, because I know I've gotten rid of, and Angela knows, I've gotten rid of a parking ticket administratively that way, that I didn't have a driver license. And I went through the Administrative Procedures Act to get them to admit to certain things, and they wouldn't. And eventually they just asked me, well, what do you want to do with it? I said, I want it to disappear like it never existed. They said, okay. So I got a letter that everything was dismissed. That's all I wanted. I didn't care about anything else.
Whenever I apply for a adjudicated hearing, I never get it. They just say, well, it doesn't appear as that you are participating in a regulated activity, so we're not going to give you one. And so, okay, I don't get one. Great. Now what happens? Nothing. There's nothing. There's the process no longer. The process stops right there.
Now, have you used any of that with the Internal Revenue Service at all?
The Internal Revenue Service has the same process. It is an administrative agency. There must be administrative process, and the adjudicative hearing at that level is called the collection due process hearing. Whenever you're levied, whenever they go to levy, you can immediately demand a collection due process hearing to make sure that they did everything they were supposed to do to verify the debt. Well, they'll kick and scream and holler and squirm, and they don't want to give you one.
So do you go through the same process?
That is the record. That is the hearing where the record is set. And you must set the record there before you apply to the district court.
Now, do you go through the same process with it?
This is very important for people to understand. Not only do you have administrative remedies, but they have them also. And so, in order to set the administrative record and set the facts, you must have that hearing. Without that hearing, it's just there's anything that's brought before the district court before that hearing is there's nothing on the record of the court to hear. In other words, there's no facts, and without those facts put in that hearing, there's nothing for the district court to hear. That's how it works, and so this is where everybody gets buffaloed. You must set the administrative record first. And then if there's any problem or any question of law, then you ask the judiciary to decide. But by that time they have screwed up so much they don't want a hearing. They won't give you one, as a matter of fact. So and if they try to move past that without giving the hearing, boy, they're in trouble.
Is that good enough for you, Dallas?
Yeah, I have one last question regarding the IRS.
Okay.
With your process, Merrill, do you go through the process at the due process hearing and having them prove that you are a person subject to their administrative procedures the way you do it with the traffic ticket and other things locally?
What happens here? I'm not sure about the question here, but let me tell you what happens. See, when they give you a citation, they're claiming that you have broken one of their statutes. Now, the only entity that can break one of their statutes is a person, okay? Not one of the people, a person. In other words, the person is defined by the statute as someone who is participating in a regulated activity. Okay, now if I was a taxi driver and I was calling people around for hire, is that a regulated activity? Say yes.
Yeah. Oh, yes, it is. Absolutely.
So now, if I was to petition the agency and say, okay, I'm a taxi driver and I got a ticket here for such and such and so and so. Are you going to show me where I'm a person under the statute? And they would call you in there and they'd say, yeah, see, you have a license here. You're hiring people for money here. That makes you, the part of the public program. You're a person under the statute, and here it is, and this is the levy we're going to put on you. You understand?
Correct.
But now, what if you're driving down the road? I mean, not driving down the road, traveling down the road in your automobile, and the cop pulls you over. It says you were doing whatever you were doing, and I'm going to give you a ticket. So now they've given you a ticket under a statute. And so does the ticket that they gave you apply to you?
I know.
If you're just traveling in your car and you're just traveling from point A to point B, none of those statutes apply to you. You're not a person because you're using the roadway as a matter of right to travel on. The taxi driver is using the roadway as a place of business. He requires a license. You see the difference between one to the other?
Yes, and then pretty much that's
so now,
what I've done.
If they were going to prove him to be a person, it would be simple. They're going to prove me to be a person. It's impossible.
Right, and that's what I've done for years. I've always separated me from the person, the man from the person, and making sure they obey their rules and leave me alone if it doesn't apply to me. I just have never heard about an adjudicated hearing. That was the first thing I heard you talked about. That was very interesting.
Were you participating in a privileged activity? That's the question, and that person must be he must be defined by the statute. I'll give you a good example. These guys, I was burning the fire out here. And I was burning some stuff up, and the cop come by and says, well, geez, there's a burn ban on. I said, well, okay, great, there's a burn ban on, so how's that apply to me? So he gave me a ticket, and so I started looking up the statute. Well, in order for me to be a person under that statute, the fire had to be so big, it had to be so close to public land. There was about 3 or 4 or 5 different criteria that I had to be conforming to in order for that fire to be illegal. But since the fire was just a small fire, it was about 2 foot across, and the illegal fire had to be bigger than 4 feet. So since I had a little small fire, it was only 2 foot across, they couldn't prove that I was a person under the statute. You understand?
Mm-hmm.
See how that works?
Yes.
Okay, so there's what they're saddled with, and so 99 times out of 100 when they give you a ticket for breaking some statute, there's no way that they can prove that you're a person under the statute. You understand?
Right.
Because the statute must clearly define you. If it doesn't, well, it's void for vagueness. I've asked for adjudicated hearing after adjudicated hearing. They've never given me one. They just write back and say, well, it doesn't appear as though you are participating in a privileged activity. Move on. And that's what I did.
Okay. So with the IRS, about a month.
Ask for a collection due process hearing. And they'll write back and tell you, you don't get one because you're a frivolous person and you're this and this and that. But I buy my book and you'll understand, okay?
I got one. I asked for a collection due process hearing and they gave me one. It was useless. It was, And I remember, God, I forgot his name, out in Vegas. He did that too. And he, told them ahead of time he was going to bring a recording device, which they have to let you do. And they said okay, but when he got there, they wouldn't let him in with it. So he wrote this big old explanation of how, he was there, but they wouldn't let him in. And the court gave him the case. He won his case against the IRS.
I have a hate brief, Angela, that I mean, everybody needs to know and have and understand. And it's in the book, and there is no way that they can deny the hearing. There's no way that they can do it and not violate due process.
Right.
So anyway,
we've got some more questions lined up here. Thanks, Dallas. Let's see here. Money Mike, you've been unmuted.
Hello. 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 I'm unmuted. Hello. Hello. Hold on. Am I here?
Hey.
For some reason, I can't hear you. What's going on?
Can you hear me all right?
Oh, there we go. There we go.
Yeah.
And
this is Vital.
Oh, wow. Vital?
No,
yes, oh, wow. Did I come into another part of the... What happened?
I don't know. Like I said, the only thing I was going to say was, Dallas talked to this man for about a half an hour. And
wow.
Dallas asked him a simple question. And the only thing the man told him to do was to go file a 1983 lawsuit against the judge. So
Carl?
that's the most. Yeah, that's me, man.
Hello?
You're talking to me. Yeah, you're talking to me. I hear you. I hear you.
Yeah,
I'm talking to you.
Actually, Angela, I was on Angela's call, and I just got on you. What happened?
Well, what's going on is Angela usually drops the call. She gets kicked off of Skype sometimes, so she just unmutes everybody she can, so we can keep the show going while she tries to log back on. So I'm trying to keep the show going for her. So like I said, the one thing Dallas asked her this man a question, and if you go back and listen to half an hour of this diatribe that this guy was going on, all he said to Dallas to do was to go file a 1983 lawsuit against this judge because he failed to give him his due process, which is ridiculous because that's never going to go anywhere. 99.8% of civil rights 1980 lawsuits are dismissed immediately. Mm-hmm. So like I said, and then the other thing, I was hoping this guy would say something about Rod Class. I was going to ask him because Rod Class does administrative procedure. And the administrative procedure that Rod Class did, Rod Class is still going around 2, 3, 4, 5 years with this stupid felony gun possession. Well, I had a friend, I had somebody who called me up, and they have a felony gun possession against them. They're an ex-felon, and they had a loaded handgun in the car while he was driving at 3 o'clock in the morning within reach. So obviously he was arrested. Obviously he had to put up bail. And then within 2-3 weeks, all the charges were dropped on him. He got a no low prosequi, letter from the state saying that they are not going to pursue it, prosecuting him at this time. So Rod Class, like I said, though, this poor guy did the administrative remedy, and it's taking years. And he's found guilty. He's got an ankle bracelet. He's under house arrest and all this other happy stuff. The guy who called me up and said to me, I just got arrested, got out of jail. What do I do? So I said, this is what you do when you go to the initial hearing when it comes to whether it's going to be an indictment handed down to the grand jury. And the judge said, yes, there's enough evidence for it to go down before the grand jury. So then when it was sending it over to the grand jury, we put 2 notices into the court and sent it to the prosecutor. When the prosecutor got the notices, the prosecutor did a no low prosequi. The prosecutor said to the state of New Hampshire, that he does not want to prosecute this man. So I sent to Angela the proof, the court document that says the case number, the name of the court, the name of the man, and that the state prosecuting attorney's office does not want to prosecute this man. He is a felon. He had a gun and within his possession in a car at 3 o'clock in the morning. They went to go collect a van from somebody who wouldn't give it back. And but it's funny, the passenger never was a felon, but he got charged. The passenger got charged with a misdemeanor. Now, the state prosecutor did not drop the charges on the passenger. And that's the passenger only had a misdemeanor. The reason why they didn't drop the charges on the passenger is because the passenger is doing administratively. The passenger has an attorney. So they're going to run the course with this guy for 6 months, a year, 2, 3, 5 years, like they did with Rod Class, because they did it administratively. And so now his friend's like, holy cow, call stuff works. So let me try call stuff. And he said to Gus, what's it going to take to call to help me? And Gus, the guy paid me, $5 to make it go away. He said, just, send him something. So I'm going to help this guy with the misdemeanor, which should be a lot easier than a felon, with a felony. But like I said, and then I helped the other guy, James, up here in West Virginia. He was charged with assaulting police officers, resisting arrest, and domestic violence. And a couple of weeks ago, he forgot to tell me. He sent me the paperwork, and I sent it to Angela, the paperwork, that all the charges against him were also dismissed by the state. He didn't make a request to dismiss the case. The state requested to the court to dismiss the case against the man. So he didn't have to do any community service. He didn't have to pay any fines. He didn't have to pay any court costs. He didn't have to do any domestic violence classes. He didn't have to do any community service. But yes, did he get into a fight with the police officers? Yes. Did he resist arrest? Absolutely. Did he commit domestic violence? You betcha. And everything was dropped. Because it has nothing to do with administratively. It's just going one man. We made contact with the police officers that he supposedly assaulted, that he touched. We tried to make compensation with the man, and they said, none is required. We don't require any compensation because no real physical damage was done to him. No broken nose, no broken bones, no blood was drawn. So they were willing to drop it. And then what happened with the resisting arrest was also basically along the same lines, and then we asked the state, to just send us a bill for the public service that public servants had to come out and perform. And they said, well, there's no bill that we could, no bill of particulars we could establish, folks, because we don't know how to itemize the cost of a cop coming out for 20, 30 minutes and doing his job. So we tried to pay off the debt to society, and there was no debt to society. So, like I said, he got, he had assaulting a police officer, domestic violence, and resisting arrest, and they were all gone in a couple of weeks. And a guy in New Hampshire, his felony charges were gone in 2-3 weeks. And Rod Class is dicking around with this stuff using Fourth Amendment, Fifth Amendment, Constitution, all this ridiculous nonsense that drags on for years. And everybody says, oh, well, if this judge does this to you, file a 1983 lawsuit against him in the United States District Court. Or like this other guy just went on saying, petition agency. Petition agency. Do you realize petitioning an agency, what petition means? It means a supplication or begging or pleading to a higher authority, to a deity. They said, do you understand that this man just said petition an agency? That means pray to God. Pray to something superior than you. Beg to something that's better than you, that's greater than you. So why would I petition an agency? That makes absolutely no sense to me. So I don't know who this guy is or what he's trying to pull. I don't know if he's a lawyer and he's trying to get you guys to fall into all this crazy nonsense. But Rod Class did this to some man I met in Indiana, and when Class did this man's administrative process and put about an inch worth of paperwork into the court, when I got to that man's house, he was charged with 4 felonies. When Rod Class got there, he was only charged with 2. When Rod Class left and gave him this administrative process remedy package, and he put it into the federal criminal court, he got charged with 2 more federal felonies for terrorism and interfering with the proper function of a government. So he was charged with 2 more federal indictments after Rod Class left. I couldn't believe I forgot to ask Rod Class about that. I was like, hey, yeah, remember our mutual friend in Indiana, Greg? Yeah, remember that guy? He had 2 IRS cases against him, 2 criminal indictments? Yeah. Well, when you left his house and you put your paperwork in, the following week he got 2 more federal criminal indictments against him. He had 4 altogether. So then when I got down there and talked to the feds for him, they immediately dropped the 2 indictments because I said he's listening to some wackadoo named Rod Class who does administrative procedure remedy. So this guy that I'm helping here, Greg, he just fixes dashboards of Trans Am's. So honestly, he doesn't know any of this ridiculous administrative remedy nonsense. He's just listening to some crazy guru who's spouting out this crazy nonsense, and he's just clogging up the court with all this ridiculous nonsense that he's not allowed to use anyway. Just like Rod Class said last week. He said that the judge in Ohio told him, look, I'm not even going to look at your paperwork that you're bringing into this court. You're not certified to give an interpretation of public law. You're not certified. You haven't gone through any kind of school. You have no accreditations. You can't use our code. You can't use our citations. You can't use our laws. Use your own. Stick with common law. If you want to talk like a man, act like a man, just say, hey, look, where's the harm, injury, or loss? But don't think you're going to bring the Constitution into our court, because we couldn't possibly give a damn what your interpretation of the Constitution is, because you've got no accreditation or certification that you have a freaking clue what you're doing. So we're not going to entertain.
Carl?
We're not going to waste time.
Yeah, Carl? Yeah, forgive me for interrupting. Yeah, this is Money Mike. Forgive me for interrupting. I just got that kind of vibe of it when I heard Merrill. It's like it seems like he was mixing everything. It's like, I mean, I know he was trying to interpret this and that, but if he's preaching the common law, but go that way. But I just couldn't understand what was going on with that. So what are your feelings on that?
When it goes with what? Okay, say that again a little slower.
Well, he was talking about administrative this and administrative that, and then all of a sudden he's talking about Constitution and
he's mixing constitutional law with administrative agency policy. When you're talking administrative, you're talking about agency policy, basically based upon an executive branch. Okay, an agency is under the control of the executive branch of a government. Okay, the Constitution defines all the branches of a certain organization. The Constitution, all it does is establishes like the legislative branch, the executive branch, and judicial branch. That's all the Constitution does. And it only has impact and control of those branches. It doesn't have impact and control over a man. Your Constitution is your skin, your bones, your liver, your spleen. That's what makes you up as a man. A Constitution just basically means the how are we going to identify, or how are we going to define this body, this corporate body, this political body, this human body. Okay, that's all a Constitution is a list of how are we going to define how this corporate body functions, or how this political body functions, or how this human body functions. So the only Constitution I have is the one that God gave me. He gave me skin, bones, eyes, liver, spleens. That's my Constitution. Now, the United States government has a Constitution. They're going to have an executive branch. There's going to be a president going to be there for 4 years. It's their bylaws. It's how they're going to define their structure, their government, how they're going to operate, how they're going to move, how they're not going to move. These Bill of Rights and all this other nonsense, like they said, half the delegates left because they said they had disagreed. Why are you trying to put a Bill of Rights in here? Why are you trying to put a Fourth, Fifth Amendment, Sixth? This Constitution has absolutely nothing to do with man. Nothing. It just has to do with the structure of our United States centralized government, which is tiny. Why are you putting in a Bill of Rights to try to confuse a man that for some reason he's subjugated to this Constitution? A man is not subjugated to the Constitution because he is his own being. This is a corporate being, this is a political being, this is a human being. They're separate entities. Why are you trying to confuse people? And that's what all these Constitution people on who go on Angela's show and anybody else's show people told me back then, when I first started this doing 2-3 years ago, they said, man, Carl, you were very, adamant against these people and you were always bashing these people. I said, yes, because they're doing this ridiculous, something to do with the President of the United States is allowed to do this. The Congress is allowed and not allowed to do this. The judicial branch is allowed to do this and not to. It has nothing to do with a man is allowed to do this or do that. It has nothing to do with it. So what are you guys talking about a Constitution that has absolutely nothing to do with you and me? So it just makes you laugh. And like I said, that Rod Class stuff was extremely funny because, like I said, his case against him with his handgun, and Rod Class wasn't a convicted felon. This guy in New Hampshire was a convicted felon. So he had a 23-year sentence on him, and they let him out in a year and a half. This guy could have went right back to jail, done the rest of his 23 years, plus charges on him for a gun. So it could have got really, really ugly for this man. And obviously this man was really scared, that he was going to spend some serious time back in jail. Convicted felon with a handgun. Everybody knows on planet Earth, holy crap, that guy is in big trouble. So like I said, he got in touch with me, and 2-3 weeks later, it was gone. We put 2-3 notices into the court, and it was gone.